Minister Indranee Rajah.
Madam Deputy Speaker, I would like to thank Mr. Louis Ng and Mr. Dennis Tan for their comments and support of the bill. Mr. Ng raised 3 points of clarification on fully virtual or hybrid general meetings, while Mr. Tan sought clarification on the location of virtual meetings and its implications, and also raised a point with regard to whether physical meetings may be still insisted upon by companies. Let me address these in turn. First, Mr. Ng asked about the court's power to invalidate meetings. As I had explained in my speech earlier, the new Section 3922A under Clause 15 of the bill will allow shareholders to apply to the court for a company's meeting to be invalidated if they suffer substantial injustice due to disruptions, malfunctions, or outages that are technological in nature. Whether or not there has been substantial injustice will be decided by the court depending on the facts and circumstances of the case. The established principles in determining the threshold of substantial injustice that have been applied to the existing Section 3922, which the new Section 3922A is modelled on, includes the following. First, there must be a direct link between the technological disruption, malfunction, or outage and the injustice suffered. Second, the injustice must be substantial in that it was real rather than theoretical or fanciful. Third, the aggrieved party must show that there may be or could have been a different result in the meeting if not for the occurrence of the technological disruption, malfunction, or outage. And fourth, the determination of substantial injustice involves a holistic weighing and balancing of the various interests of all the relevant parties. In other words, the court will take a holistic and balanced approach in determining whether a meeting should be invalidated depending on the facts of the case. While the court has the power to invalidate all or only a portion of a meeting, it will be used judiciously. Invalidation is usually the relief of last resort where other remedies would not be appropriate in order to achieve a just result. For example, in cases where the substantial injustice suffered cannot be otherwise remedied by any other order of court. Next, Mr. Ng asked if we have considered introducing new offences to punish individuals who disrupt fully virtual or hybrid meetings through technological means with the malicious intention to invalidate these meetings. At this juncture, there is no need to introduce new offences for such a situation. There are existing legislative levers, such as the Computer Misuse Act of 1993, to investigate any deliberate or malicious disruption, such as by way of hacking. Mr. Ng also asked if guidance will be provided on the best practices for conducting meetings using virtual meeting technology. The answer is yes. The various regulators have already issued or will issue materials drawing from the lessons learned in conducting such meetings during the COVID-19 pandemic. For instance, ACRA will be issuing a set of frequently asked questions to directors and companies on the legislative amendments for virtual and hybrid meetings. These FAQs will be updated on an ongoing basis to address common queries received from the public. SGX Practice Note 7.5 on general meetings also provides more detailed guidance to listed issuers on how hybrid general meetings may be conducted. The practice note provides details on the requirement to provide shareholders with the opportunity to ask written questions within a reasonable time prior to general meetings and the safeguards required to validate votes. In addition, the SGX, the Singapore Institute of Directors, and Chartered Secretaries Institute of Singapore outlined standards for service providers of virtual meeting technology. This set of standards enhances the market's understanding of virtual meeting technology and facilitates effective shareholder engagement. Mr. Tan had raised a couple of points. The first, I think, on what happens if companies still insist on having physical meetings. As far as the amendments go, What the amendments do is that they provide an additional option. So currently, you can have physical meetings, but what the legislation does, it enables companies to also choose a hybrid option or a virtual option. We did not want to be overly prescriptive because generally this is something that should be left for companies to decide. And I think one of the things that that investors will surely take into account is the ease and convenience with which they can transact their dealings with the company. Clearly, this is something that we will watch and see whether any further amendments need to be made. But the current situation is such that the options are there. We leave it to the companies to determine what is best for themselves in terms of how to conduct business. And I feel fairly sure that if they chose a course of action that was inconvenient to their shareholders and their investors, the likelihood is that the shareholders and investors will give the necessary feedback that will enable the company to change its practice. The second clarification that Mr. Tan had raised was where virtual meetings would be deemed to be held jurisdictionally and the implications that that might have on the tax residency of a company. The Companies Act, in general, as it currently stands, does not prescribe jurisdictional requirements for where company meetings are deemed to be held. And the amendments being introduced today do not make any change to this position. So in short, nothing that is being moved for amendment today will change what is currently the law under the Act. Specifically, the amendments only clarify that nothing in the Companies Act prevents Board of Directors meetings from being conducted virtually and doesn't change the current position in the Companies Act where Board of Directors meetings may be conducted virtually. Similarly, the tax residency of a company will continue to be determined by where the business is controlled and managed, which is where the decisions on strategic matters are made. Ultimately, a company's tax residency would be determined on the facts and circumstances of each case. I think that the specific question that Mr. Tan has in mind is that because in the case of a virtual meeting, you don't have one particular location. So where do you say that the meeting has been held? Thus far, the courts have been able to make determinations on where the company's place of residence is for various purposes. I would not think that that would be very different in this case. So without in any way constraining how the courts may decide to determine the matter, one imagines that the court would apply first principles, such as, for example, looking to see where the company has its management and control located, and relevant factors may include where the meeting was organized, where the material was sent from, basically where the organizational center of that meeting was. But like I said, I don't wish to constrain the courts in any way, and they should have the full ability to decide based on the facts and circumstances of each case. These amendments will enable entities to conduct virtual or hybrid meetings should they do so, and they should be mindful of the regulations issued by the respective regulators. So, for example, SGX has publicly communicated that SGX-listed issuers may conduct physical or hybrid general meetings from 1st July 2023 onwards. This provides issuers added flexibility to decide the format of meeting that suits their shareholders' needs and facilitates shareholder engagement. Madam Deputy Speaker, let me conclude. These proposed amendments will permanently provide companies, business trusts, and variable capital companies with the option of conducting fully virtual or hybrid meetings through the use of technology. The other amendments also strengthen Singapore's corporate governance regime by upholding market confidence and safeguarding public interests. These amendments are crucial to ensure that our legislation remains relevant and future-ready. Madam Deputy Speaker, I beg to move.
No clarifications. The question is that the bill be now read a second time. As many as are of the opinion, say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Companies, Business Trusts and Other Bodies, Miscellaneous Amendments Bill.
Committee stage, what day?
Now, Madam, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of their opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 28 stand part of the bill. As many as are of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Second Minister for Finance.
Madam Deputy Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading, what day?
Now, Madam, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Companies, Business Trusts and Other Bodies, Miscellaneous Amendments Bill.
Order. I propose to take a break now, and I suspend the sitting, and we'll take the chair again at 4 p.m. Order, order.